Well, hello, everybody, and welcome back to Raw Law Unfiltered with your host, the DUI guy. Plus, what do you all think of the upgrades? I am continuing to test with the background and the lights and the microphone. So let me know in the comments below if this is better or worse. Um, Absolutely want to know your thoughts on this. But our main event today, as you all already know, we have a brief submitted by friends of the court. That is the literal definition of amicus brief. Now, we'll take a bit of getting used to. Sounds good, Deanna. So here's what we've got going on. Let's start with the basics. Okay? Let's start with the basics. What is an amicus curiae to begin with? It's a Latin term. What does it mean? It means, like I said, the literal translation means friend of the court. There's going to be a background. There's going to be a background. This is not the end of the setup. I'm working on getting a backsplash together. So for now, it's going to be a little bland and boring. So I apologize for that. But anyway, the Legal Information Institute defines amicus curiae as a reference to a person or group who is not a party to the action. By the way, happy Thanksgiving, everybody, if I haven't said that already. My mind is in like 100 different places, and I'm trying to make sure that I cover all the bases today. If you're in the US, happy Thanksgiving. Generally, it references a person or group who is not a party to an action, but has a strong interest in the matter. This person or group will petition the court for permission to submit a brief in the action, intending to influence the court's decision. Such briefs are called amicus briefs. Or when there's more than one, the plural is amici, okay? Or I know you all have been joking, and that's why I included it in the title below, Amica brief. But let's get serious. So what does it all mean? For those of you who may or may not, I know Laura B, who may be watching this, by the way, shout out to you, Laura, if you are in the chat. There are a couple of versions of this rule from Virginia. This is the rule. Now, you got to be careful which one you're looking at. This one is effective until January 9th. Okay? It gets slightly modified, and the rule for amicus briefs is going to change starting January 9th. So this rule is not currently active. This rule will be active in about, 45 or so days. So we're not going to be looking at this one. We're going to be looking at the rule that is currently active regarding briefs amicus curiae. So the stage of proceedings. This is how the rule begins. Subject to the requirements outlined in this rule, a brief amicus curiae may be filed during the petition, perfected appeal, or rehearing stages of the appellate proceedings in this court, and in proceedings invoking this court's original jurisdiction. Fancy language. Basically means you are permitted to file this so long as you follow these guidelines. Who may file without leave of court? The state and the United States government. However, everybody else requires leave of court. That means they need to request permission. They can't simply file and call it a day. the court still has to agree and accept it. Okay. So far we have 2 amicus briefs that have been filed. And my guess is there aren't going to be any more forthcoming. And we'll get to why in just a moment. The second one we will cover tomorrow on Thanksgiving or presumably Friday. Depends on how my schedule is. If I can squeeze it in tomorrow. Except as provided in paragraph B of this rule, any person or entity seeking to file a brief, amicus curiae, must obtain leave of court by motion. This is the key language right here. And you will see that in the brief today and tomorrow. Must obtain leave of court. Such motion must state whether the brief would be in support of the appellant or the appellee, or in support of none of the parties. Maybe you're just indicating your own interest and interjecting yourself. You must, 2, certify that the applicant for the amicus curiae has sought to obtain consent of all the parties to the appeal, because some parties may not consent to the amicus being interjected, and state which, if any, parties have consented to the motion. We'll get to that once we cover the brief. Now, when must they be filed? So now we get to the very, very interesting crux of this whole thing that has been unraveling over the last few weeks. If you remember, Amber Heard's brief was originally due November the 3rd. Now, October 18th, I believe, her lawyers requested an extension. They requested a 28-day or 30-day extension. Ben Chu and his team objected. They said, you don't need an extension. You shouldn't get one. The court split the baby, as they often do. They gave Amber Heard's team 21 days. That's today. Why did they ask for it? That has always been the question, right? Are they not in time? Like, what is going on? Now we know. There were 2 firms working under the surface in drafting these Amicus Curiae briefs. Because look at the rule. Look at what the rule says. A brief, Amicus Curiae, must be accepted only if filed. Oh, excuse me. Amicus Curiae will be accepted. I don't know if I said must. That was not my intent. Will be accepted only if filed on or before the date on which the brief of the party supported is required to be filed. Now we have an answer. This is why Amber and her team needed an extension. Because if they had filed on November 3rd, let's say, and the Amicus Curiae would have filed after that date, it will not even be looked at or considered, no matter what motion or leave of court that the Amicus Curiae may request. So a brief Amicus Curiae may be filed at the time of the filing of the reply brief of the appellant only if an opening brief Amicus Curiae has been filed. So you don't get to backdoor a reply brief later on. So basically, in layman's terms, Amber Heard's brief was originally due November 3rd. Any Amicus Curiae would have to be due on or before November 3rd. Period, the end. However, they requested and were granted an extension. That extension allowed Amber Heard to file her brief, which presumably was filed today. We just don't have a record of it because the clerks, I mean, it's Thanksgiving Eve, for God's sake. Like, I understand why we don't have a brief yet. It's okay. It's not a big deal. When I say we don't have a brief yet, I mean we don't have it like recorded. It's been sent. It's with the court. I have almost no doubt about it. It's just the way this stuff works. I've been a part of it so many times, so I can tell you from experience. I know a lot of people just want to throw her under the bus and be like, well, what if she didn't get it in? And what if she da, 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 da? Don't worry. She got it in. She got it in on time. We just don't have our hands on it yet. However, if a person or entity is filing an amicus brief that is not in support of either party, which is not the case here, it will only be accepted if filed on or before the date on which the appellant's brief is required to be filed. So that's the guideline for, but that doesn't apply here. This is what applies here. What must it contain? So it must comply with the rules and so on. We're not going to read the rest of this rule as it's not really applicable or necessary in this case. But this is what you have to walk away with. This is why Amber requested that extension. This is the language that explains why Amber needed an extension. It's for her Amici brief number 1 and Amicus brief number 2. Again, why the difference? Amici plural, Amicus singular. One is on behalf of organizations supporting sexual abuse, domestic violence, women. The list is in the description below, by the way, if you're curious. You'll see it on screen in a moment. And so the firm that filed this brief is Simpson Thacher. Simpson Thacher and Bartlett LLP is their full title. They needed a lawyer licensed to practice law in Virginia in order to file this because they either didn't have time or basically didn't quite need anybody to pro hac vici or test into the Virginia bar because of this guy. He's licensed in Virginia. He's with the firm that filed the brief, Amicus Curiae. He's a lackey. He's a nobody. They're just using his Virginia license in order to file these things. Now, the rest of the team, again, some of the names they're just young guys and gals. I mean, Damian Gallagher literally just graduated with his LLM. Eric Yang, a couple of years ago. Sorry, I can't get rid of this thing. It won't. There we go. Every time I my cursor goes up, it like opens up their menu. We got Jacob, also just a couple of years out. And then we have a couple of heavy hitters that have been involved in this brief. None of which really directly have a hand in this case, in the understanding of the topic, in my opinion, but we'll see. Sarah Phillips represents clients in a wide range of high-stakes commercial litigation matters, including complex multi-jurisdictional cases with a focus on securities and insurance litigation. None of those things are happening here. She has also extensive experience advising clients in government and internal investigations. All right. And finally, we have John. John Terzakin. I believe I'm pronouncing that correctly. Again, an antitrust litigator and formal federal prosecutor. He's the co-chair of the firm's antitrust and trade regulation practice. I'm not exactly sure why they picked this team of lawyers, but it is what it is. So, with all of that in mind, let's dive in to the brief itself. Here we go. In the Court of Appeals of Virginia. Oh, by the way, before I get started, you all like my mug today? Shout out to you, Tug. Mm, mm. I don't know what it is about this mug, but everything tastes exceptionally good from this mug. If you all don't have one, they're on his merch website. Absolutely go check it out. Shameless plug for you, Tug. Yummy. All right. In the Court of Appeals of Virginia. This is the heading. It is the brief of the Amici Curiae, Sanctuary for Families, Virginia National Organization for Women, I believe that's NOW, the DC Coalition Against Domestic Violence, Equality Now, Esperanza United, the Feminist Majority Foundation, Battered Women's Justice Project, the Women's Equal Justice Project, and on and on and on. You get the idea. Now, this is the council that I just mentioned. There's Sarah, Jacob, Eric, Damien, John, and Jeffrey. Jeffrey being the only one licensed in Virginia State Bar. There's his bar license, there's their address and everything. And the rest are not actively admitted in Virginia. The table of contents. So just to give you a brief overview as to what we're going to be going over. They start with a table of authorities, which we're basically going to skip over, but I believe they even cited a case where Boozy was involved, which I thought was kind of funny. But hey, a case is a case is a case. As a lawyer, I can't hate too much. I don't know the factual and legal basis of the case because it never come across my desk. Identities and interests of the Amici Curiae, like who are they and what are their interests? The source of authority to file, they're going to cite the rule that I just read to you, 5.3, statement of the nature of the case, assignment of error, and then they're going to go into the statement of facts and standard of review. Okay, so that's going to be fairly fast. And then the meat, the argument. They're going to start with the following argument. The jury verdict was plainly wrong to ignore uncontroverted evidence of widely recognized forms of abuse. We're not going to be discussing them here. This is just the overview. We will begin discussing them individually as we hit them, okay? A, undisputed evidence demonstrates that Ms. Heard was subjected to emotional, psychological, and verbal abuse. In Virginia law, as well as national and international authorities and scholars, recognize Mr. Depp's conduct as abuse. All right, so that's their point number one, A and B. Their main point number two is going to be allowing the verdict to stand creates a harmful, chilling effect on abuse victims seeking relief. It's kind of like the slippery slope argument, I imagine. The verdict discourages domestic abuse survivors from seeking protective orders. That's going to be argument A under 2. The verdict emboldens retaliatory defamation lawsuits, further chilling victims from seeking relief. And C, 3, the verdict fosters a climate of second-guessing victims. Isn't that what we want? Hey, Alexander, thank you very much. Says some other coffees for other explanation that otherwise I would not understand. Well done, Mr. Teacher. Thanks, brother. Don't we want a second guessing of victims, especially if they're lying and we don't know if they're lying and we want to verify if they're lying? Now that's a chilling effect if I were to state one. But okay, I can't wait. I literally just got my hands on this, so we are going to be dissecting it together. So here are the cases. Let me just kind of zoom out a little bit. These are the cases that they're going to be citing. We're not going to be going over this list. This is all standard stuff. They start with the United States Supreme Court and Virginia cases for the most part. Then we have some statutes cited, Supreme Court rules, Supreme Court of Virginia rules, and some other authorities that are going to be used throughout. Now, it's interesting. The first thing that I can already tell you that I noticed in this amicus brief is that there are only like 12 or 15 cases cited, a few statutes, and then we go to other authorities, which is already a red flag. If I'm a judge and I'm reading this brief, I mean, that's a huge red flag, because now you're involving emotion into a case that we are supposed to be deciding based on the law. And emotion has no place in law. I want to see your authority. I want to see your cases. I want to see your statutes. I want to see your Supreme Court cases. I want to see your Supreme Court rules. I don't care as a judge, as an appellate court judge. I don't really care about your other authorities. I mean, it's cute. It's nice. I'm glad that you have it in there. But having this list literally like being thrown in my eyes as an appellate judge, and it goes on to a second page. Does it go on to a third page? It goes on to a third page and a fourth page. I mean, now I'm starting to I'm as a judge, fifth page. I'm literally scrolling through this. I'm not going to be reading all of this. I'm going to be reading it in context, but I'm not going to be checking every single one of these, and let alone opening it up for the most part. Maybe one or two I'll click on as a judge to just kind of get an idea, maybe if I'm interested in the topic. But we have like literally 6 pages of trying to brainwash judges emotionally. Huge red flag. It has no place in a brief whatsoever, especially an appellate brief. All right. So who are you? Let us identify ourselves. The Amici Curiae, Amici moving forward, are leading nonprofit organizations. So we have those, professors, victim advocates, and professionals around the world dedicated to advancing the safety and well-being of survivors of domestic violence. Right there, right out of the gate, I can already see, again, as an appellate judge looking at this, this is going to be very emotion-centric, not law-centric. Something I need to keep in mind in the back of my head. Don't forget that these are going to be read, if they're going to be read at all, after the judges read all of the briefs in the case. That means the opening brief, the response, and the reply. Because those are the central parties to this case. Okay, don't forget, the central parties are not these people. It's Johnny and Amber. That's it. Their lawyers are writing and speaking on their behalf, and these parties and these lawyers are simply interjecting themselves because, remember the definition, they believe that they have an interest in this case of some sort. Now, again, we're about to find out more in depth, but just because they wrote this does not mean that, first of all, it's even going to be read by the judges, because the judges still have to accept the Amicus Curiae. And it's very possible, since Johnny Depp's team objected, that they may not even take this into consideration. So that is still a question that remains to be seen. Let's get back into it. Collectively, Amici provide a broad range of legal and other services to victims of domestic violence and are active contributors to and experts in, there's that lovely word they like to throw around, the scholarship surrounding the dynamics of domestic violence. Amici are concerned because the jury verdict reflects a deep and dangerous ignorance of the coercive tactics and non-physical forms of abuse that are a critical component of domestic violence. And by the way, on this point, real quick, Court of Appeals judges, this is crucial. This is like one of these moments that if you're going to clip anything, clip this right here, what I'm about to say. Court of Appeals judges defer to juries and judges in the lower level. Why do they do that? Because the appellate judges were not in the courtroom. They didn't watch the witnesses. They didn't see their faces. They did not hear the testimony. They are going to be deciding this case based on the law. Okay? So when you, as an amicus curiae, interject yourself and say, look, they got it wrong, again, I, as an appellate judge, immediately kind of step back and go, look, I wasn't there. You are more than welcome to make your own judgments. I am going to defer to the jury's decision. That's the way Court of Appeals judges reason and write their appellate opinions. Okay? So by trying to argue right out of the gate here that the verdict is basically wrong and lacks and is ignorant of this and that, it literally detracts from the brief. I, as an appellate judge, am reading this and going, what else you got? Because your appeal to emotion and your appeal to coulda, shoulda, woulda, I don't really care about. I care about the law. Were there any violations of the law? If there have been, then it must be reversed, sent back. If there have not been, then the verdict must stand. We are not, this is an attempt to retry the case. And this is not the place to try and have a second mini jury trial with the judges as the jury. That's not how the legal system works. The amici also wish to advise the court of the troubling, chilling effects. This highly publicized verdict. Okay, so we lost somewhere where we really could not have possibly lost is a terrible argument. Too many people have eyes on this and we are losing ground is not a good argument. We'll have the effects that it will have on victims of abuse seeking to protect themselves, report abuse, and raise awareness. Again, it's like, okay, we had a fake victim. She turns out to be a little too high profile for us. Please fix. Huh? Pursuant to Rule 5A23, amici respectfully submit this brief in support of appellant Amber Laura Heard. We are qualified to understand and express the interests of domestic violence victims in Virginia with respect to matters of common concern that come before this court. Again, just meaningless language. Amici requested the consent from all, and by the way, you'll hear me use, these are Latin terms. I've heard them both ways. You want to criticize me on my pronunciation, by all means, go ahead, but I'm just going to be going all over the place. Amici, amici, amicus, they literally all mean the exact same thing, just different pronunciations in different parts of the world and the country. There are Latin terms, dead language. So they request the consent from all parties to file the Amicus Curiae Brief. Appellant Ms. Heard consented. Obviously, it's on her behalf. Duh. Appellee, Mr. John C. Depp, opposed. So there it is. There is the beginning. Remember the rule. The rule says you must ask both parties, do they consent? Let us know which one did and which one didn't. And then we're going to take it into consideration. So there's so many layers to an amicus brief in Virginia. First of all, they don't even have to accept it, right? Even if they do accept it, they may not even read it, in which case I guess they won't even accept it, right? Because they won't read it. They may say, look, Johnny Depp opposed. No, thank you. Next. All right. A full list of Amici is attached here to his exhibit as Appendix A. Now, the source of the authority to file. The Amici have moved for leave to file this brief in the accompanying motion pursuant to Supreme Court of Virginia Rule 5A23. We read that rule together. We know where it comes from. The statement of the nature of the case. This is where they're going to give a broad overview of what's going on here. Though Johnny Depp's defamation claims are facially limited to 3 statements made by Amber Heard in a Washington Post op-ed, the record in this case makes plain that Mr. Depp used his lawsuit to retaliate against Ms. Heard, you mean for her lies, for obtaining a temporary restraining order against him 6 years prior. Oh, so he used it as a weapon. Okay, all right. In an effort to escape Mr. Depp's increasingly insufferable abuse. At trial, Mr. Depp painted the traumatic events that led to Ms. Heard's protective order as an elaborate hoax perpetrated by Ms. Heard against Mr. Depp, the true victim. Mr. Depp's ploy was successful. It was not successful because Mr. Depp carried his burden to demonstrate by clear and convincing evidence that the alleged defamatory statements regarding abuse were made with actual malice. By the way, that statement right there literally says the jury was wrong. The jury made the wrong decision, which is not something you want to lead with in an amicus brief. I told you we're going to be having fun reading this shit. This is nuts. This is nuts. I think a college student could have written a better brief. You don't lead with the jury got it wrong. Argue the law, not your passion, your emotion. This is not the trial court level. The alleged actionable statements were, I spoke against sexual violence and faced our culture's wrath. That has to change. Then 2 years ago, I became a public figure. You remember all of these. I'm not going to go through them. They're just reciting them. So actual malice, a subjective standard that requires proof Ms. Heard recklessly disregarded the truth. Rather, as a post-trial interview with one juror revealed, the jury found in favor of Mr. Depp because while, quote, the jury concluded they were both abusive to each other, Heard's team failed to prove Depp's abuse was physical. Remember, that was the one, I think, NBC interview that they did with one of the jurors. He came forward, I think it was a he, came forward based on the language that they said. I think we determined it was a he, or maybe they said it was a he. I can't remember. And we did think it was the older gentleman, also known as juror number 6, but we could be wrong. We could be wrong. So that statement, they're basing it off of a statement that came allegedly without any confirmation. Again, it's just making themselves look worse and worse. Not a good look for a appellate brief that appellate judges are supposed to take into consideration in making their determination whether or not the trial court erred as a matter of law on certain issues. The jury's singular focus on allegations of physical abuse is contrary to the evidence presented at trial and demonstrates a fundamental misunderstanding of the law. What? I think my brain just shut down reading that statement. Let me read that again. The jury's singular focus? First of all, how are you determining that this was their singular focus? Based on a hearsay statement that we don't even know at the end of the day where it came from? You trust NBC? You trust that it was a real juror? This was not part of the trial. Jury deliberations are done in secret. So again, they're leading with very weak, unsubstantiated hearsay arguments. Not a good look. The jury's singular focus on allegations of physical abuse is contrary to the evidence presented at trial, but they're the ones who get to decide. They're the ultimate arbiter of fact. Again, jury got it wrong is not a good argument. The Court of Appeals is going to defer to the jury's judgment because they were the ones who sat in the courtroom for 6 weeks and listened to the evidence. I guarantee one of these days when we get the decision from the judges, after all of this is wrapped up, there is going to, mark my words, there's going to be a statement somewhere in the opinion and order from the Court of Appeals of Virginia where they're actually going to say the words, we defer to the jury because they were the ones who actually witnessed the case, watched the video, listened to witnesses, and are the ultimate decision maker. So when you're throwing all this stuff around, it just shows the weakness of your case and the weakness of your position. Is contrary to the evidence presented at trial and demonstrates a fundamental misunderstanding of the law. The jurors are not there to decide the law. The jurors are there to decide the facts as they and how the law applies to the facts. The law was clear. And at the end of the day, let me let you in on a little secret. Even if, which is not the case here, but even if the jury did, let's say, got it wrong, again, the Court of Appeals is going to defer to their judgment because they were there. That's the beauty of the legal system. Because imagine if every juror's decision will become into question, like, what did they talk about? How did they come to this decision? The whole system would collapse. The conduct by Mr. Depp laid bare at trial, poor choice of words, in text messages, audio recordings, videos, and his own testimony. So he testified, right? Remember that. You all remember that. Demonstrated that in addition to physical abuse, Ms. Heard was the victim of emotional, verbal, psychological, and other well-documented forms of abuse. These additional types of conduct all fall within widely accepted definitions of abuse in the Commonwealth of Virginia and in the scholarship of domestic violence more generally. So first they said the jury got it wrong, and now they're saying how they got it wrong. The trial court rejected Ms. Heard's request to provide the jury with an instruction on what amounts to abuse. Finally, you're getting to at least one piece of meat in this case. The instruction. So this instruction should have been included, and here's why. As a result, the jury improperly disregarded non-physical conduct when considering whether actual abuse occurred, and more importantly, whether Ms. Heard believed Mr. Depp's conduct amounted to abuse as required under the actual malice standard applicable in this case. Okay. The Amici respectfully submit that in conducting its independent review of the record, this honorable court will find ample, uncontroverted, terrible words. Okay, let me just ample, uncontroverted. When you use adjectives to try and make you look more like you have a better argument than you actually do, you again detract from your brief. You detract from your argument. You detract from the facts. You detract from your persuasiveness. Briefs are supposed to be written in an ice-cold manner, matter-of-factly, factually. Don't give me, I don't want to read as an appellate judge. I don't care about your uncontroverted, ample, vast, laid bare. Just talk to me. You will find evidence in various forms. Literally, that right there, listen to it. It even sounds better. You will find ample evidence, or you will find evidence, but ample, uncontroverted is just weasel words, fluff, empty fluff that only detracts from your argument. Ample, uncontroverted evidence of various forms of abuse suffered by Ms. Heard at the hands of Mr. Depp. As such, Ms. Heard's statement that she became a public figure representing domestic abuse could not be false, but as we learned, it was. She used it as a weapon, let alone made with actual malice. Again, they're questioning the jury. They're back to questioning the jury's determination. I would have literally just kept this one little paragraph and thrown everything else in the trash when it talks about the jury improperly disregarded and the judge improperly excluded that instruction. That would look so much more powerful. But when you throw in all this unnecessary garbage, you're weakening your position, because it's like these people who wrote this brief, I swear to God, I'm starting to get the feeling that they've never practiced appellate law before. They do not understand how appellate law works. You don't argue emotion. You're not trying to persuade them and sway them emotionally. Jesus Christ. Became a public, okay, let alone made with actual malice. The court should therefore conclude, finally, we get to something again, the trial court erred in not setting aside the verdict. That's not what the court should be deciding. The court should therefore conclude that the trial court failed to include a proper instruction, should have included that instruction in the jury instructions as they were given to the jury, and therefore the verdict should be set aside. That's how you write that statement. Unbelievable. This is so poorly written. I mean, it was clearly rushed, but I mean, come on. Such a finding will not only rectify the injustice served in this case. Again, they're making it sound way bigger than it is because they really, really desperately want to win, which makes sense. It's understandable. It's understandable. They really want to win, but just really, 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 really wanting to win is not a good argument. So we'll not only rectify the injustice served in this case, but also send a message to those who may seek to improperly use defamation lawsuits or other legal proceedings as a means to retaliate against victims of abuse. So basically, they want victims to be able to file these things with impunity. Once I file domestic abuse charges against you, you don't have a right to retaliate against me and say that I'm a liar. Even though I may be a liar, you don't have a right. That's literally what they're trying to ask the court to do. It's bonkers, absolutely bonkers. They want like a bubble of protection where once charges are alleged, you cannot be contested. Very much reeks of that Vogue article. Remember the Vogue article that we glanced at during the trial? It is time to believe women, all women. Like basically, don't look at the evidence. Don't look at the evidence because the evidence doesn't matter, as Dr. Proudman so aptly wrote on her Twitter not that long ago. Forget the evidence. Look at the allegations. Everything else is just cannon fodder. Terrifying, disgusting, unreasonable stuff. Unbelievable. And now they're arguing it here in the brief. That is, I did not expect this. I did not expect this. I'm going to be honest. I expect a lot from these people, but to argue that you don't even have a right as the one being accused to respond, that is absurd. That is literally taking away your power to litigate when you feel that you are right. Like you, again, remember, it follows the whole trend, right? We don't like what you were saying, so we're going to get you canceled. We're going to shut you down like we did with Nick Rekieta. We're going to cancel your channel. We're going to delete your channel. We're going to delete you off Twitter. Well, guess what? Nick's fucking back. Nick is back on Twitter. Nick is back on YouTube. Why? Because it was wrongful what was done to him. But that's what these people do. They can't stand the fact that they can be wrong. Amber used your movement. It would look so much better on you if you simply take the L, realize that there are fake victims out there, and move on. That's all we have to do. Instead, this is going to continue on for another few months. Did you all hear Zinnia? She's in the other room, um, walking around. I'll let her in a little bit. She's distracting. She was very, very energetic tonight. So I wanted to make sure that I'm able to do this. I can't believe the microphone picked up on that. That's really interesting. Anyway, back to the brief. Indeed, an abuser's misuse of the legal process, you mean Amber, right? To further control and coerce their partners, referred to as legal abuse, is itself a widely recognized form of domestic violence. So this paragraph, I know they're trying to make it about Johnny, but this is exactly what Amber did. She wrongfully filed a TRO, and she wrongfully accused him of domestic violence. But they're trying to paint it on Amber as Johnny's the one who abused the legal process. So again, it's the flipping the script. And I get it. Each side is going to be like, well, they're flipping the script on us. Well, no, they're flipping the script on us. I get it. I get it. The verdict in this case, but the jury has spoken. That's the bottom line. The jury has spoken. The world has spoken. Hollywood has spoken. The law has spoken. For now. The verdict in this case is part of a growing and troubling trend of individuals accused of abuse and harassment using lawsuits as a tool to silence victims. Now, make no mistake, that statement right there does have a little bit of merit, because there will be situations where very powerful abusers, okay, powerful abusers with lots of power and lots of cash could potentially abuse the legal process in trying to silence victims. But here's the problem. They will still not be successful, because all the victim has to do is to let it go all the way to trial, where it will come out who the real abuser is, and the jury will decide. So there's a fail-safe mechanism. It's not just between lawyers and prosecutors and some judges, or attorneys and some judges. It's the public. That's why we have juries, where the public is injected into the courtroom, and the public gets to decide whether or not this happened or didn't happen. And if so, how much? And if how much, then you got to pay. That's literally why we have juries. Tracy says that the tapes made it clear that she was the abuser. If you all don't know which tapes we're referring to, I think Incredibly Average has a slew of tapes. Go check out his channel, subscribe to him, and while I'm at it, don't forget to like this video, comment below, and subscribe to this channel. All right, back to the brief. As the New York Appellate Division First Department recognized in Segale versus Carrega, quote, sexual assaults remain vastly underreported, primarily due to victims' fear of retaliation. It does not escape us that defamation suits like the instant one may constitute a form of retaliation against those with the courage to speak out. That's from 2021. But again, here's the issue. If the victim can afford it, of course, if such a situation arises, all you have to do is take it to litigation. I mean, heck, you may even want to represent yourself if you can't afford a lawyer. And that may work. It will not be a Daryl Brooks situation, because if the judge does see you as a victim, if you truly are and you're just trying to fight for your rights, you know what? I will bet money. I will bet fucking money that the judge will very quietly and very carefully listen to you and let you articulate your case at a jury trial. And if you make mistakes, the judge will see it through. And you know what will happen before it gets to that point? The plaintiff will drop their lawsuit, because they do not, if they're truly the abuser, they have no reason to continue forward once they realize their back is against the wall. This is what people fail to realize. 4C process says, remember when AH attempted to sue JD for defamation first, also sued his friend Doug Stanhope for defamation too, and both were dropped for different reasons. 4C process is right on the money. Thank you for saying that. That's exactly what it is. The truth wins. Truth wins. Hashtag that shit. It's already been there. The truth will set you free. Truth wins. And in this case, very, very important. Very important. And in future cases, all of this is extremely important. Who the victim is and who the abuser is when public scrutiny is involved, when your dirty laundry is out there to dry, the truth will come out and the truth will win, because truth wins. Similarly, in her report to the General Assembly, United Nations Special Rapporteur on the Promotion and Protection of the Right to Freedom of Opinion and Expression, Irene Khan, warned of a perverse, this is a quote, a perverse twist that women who publicly denounce alleged perpetrators of sexual violence online are increasingly subject to defamation suits or charged with criminal libel or the false reporting of crimes. And here's the bottom line, by the way. Thank you very much, Crazy Goalie Mama 14. Hi, Larry. Happy Thanksgiving tomorrow. Thanks for all that you do. You're welcome. You're welcome. And you know what that statement tells me, by the way? Just real quick. That statement that women who publicly denounce alleged perpetrators of sexual violence online are increasingly subject to defamation suits or charged with criminal libel and false reporting of crimes. Well, that means that's a real thing. The tide has been shifting. That's what that tells me. The tide is shifting. Women are starting to use false allegations as a weapon against men in their rise to power. That's what that tells me. So if this is becoming a problem, that means because it is a problem. The true allegations, sure, they happen. Sometimes they are reported, sometimes they are not reported. But the reporting of false allegations is on the rise. That's what that tells me. And that by itself is horrifying. So to try and stop it in the tracks now is literally the worst thing you can possibly do. I remember when I was a kid, my parents always warned me, be careful of women. Certain women will not hesitate to lie and throw you under the bus. And they told me horror stories. We all have heard them about boys being accused and going to jail over things they didn't do. Claire Harris, thank you. Early on in this, it lists the type of abuse she was subjected to, but missed physical sexual assault. And now it's saying there was sexual assault. Can they decide, please? Right. Exactly. Thank you, Okie Granny. All right. This phenomenon creates a troubling, chilling effect on survivors. What about the false accusers? Or the falsely accused, excuse me. on survivors of abuse seeking to access justice to protect themselves and prosecute abuse. Those days are dead. Those days when a woman will, because of this trial, because of the falsity of these allegations that went viral, these days are now officially dead. The days of the Me Too, and everybody's like, oh my God, I believe you. What happened? Those days are dead and they will never be revived, no matter how much you try and how much you write Amici briefs on the subject, or how many TikTok videos you make. It's because of this case, this widely publicized case, to show that yes, women do lie and they do make up allegations, false allegations against men themselves. All right. All right, hold on. Let me let her in, because this is torture. It feels like. Hi, Zini. Come here. Come here, baby. Aw. Say hello to Zinnia, everybody. Say hi, Zinni. Let me make this bigger. She is. Hi, Zinni. She just wants to join the party. We're reading the Amicus brief on behalf of Amber Heard. Did you know that? Yeah, she's my baby. All right. Now she's just going to lay at my feet, probably. Amber Heard. Now I got hair in my mouth. Amber Heard deprived Johnny Depp of his due process of law, says Tammy Hoshiyama, for never allowing him to answer the TRO in the court hearing attached to the TRO. Very true. So, I lost my place. Already, clients of Amici have expressed fear as to how the Depp v. Heard verdict may impact their ability or willingness to pursue legal remedies against domestic violence. And you know what? I empathize with them. I truly do. The real ones, the real victims. It will have an impact, no question about it. Absolutely no question about the fact that this case will have an impact on real victims everywhere. But you know what? That's not a reason to undo the legal process completely. And if you are a real victim, you absolutely need to come forward. Because abusers need to be behind bars. They need to be known, the real ones, not the fake ones. A meritorious reversal of this case, which has been widely publicized and closely watched by victim support and advocacy groups all around the world, will serve to reinforce that the rule of law supports and does not hinder the ability of survivors of all forms of abuse to speak up, seek help, and encourage others like them to be brave enough to do the same. And by the way, this case has not done any of these things. I don't believe it. I don't believe it. To the contrary, I think it dissuaded false accusations, if anything, which is fantastic. All right. Now, assignment of error. This is the error that they're arguing. The Amici support Ms. Heard with respect to assignment of error number 14, which reads, the trial court erred in denying the motions to strike and set aside the jury's verdict with regard to Mr. Depp's failure to prove actual malice by clear and convincing evidence. Appellant's designation of assignment of errors, paragraph 14. So this is what the whole brief by the Amici is going to be about. The striking and setting aside the jury's verdict with regard to Mr. Depp's failure to prove actual malice by clear and convincing evidence. Statement of fact. Ms. Hurd's statement of fact is accurate and is incorporated herein by reference. And now we go to the standard of review. How is the Court of Appeals to look at the case, and how are they going to have the power to adjudicate one way or the other? On appeal, this court may overturn the trial court's denial of a motion to set aside a jury verdict if the denial is plainly wrong or without evidence to support it. That's the law. That's the standard. This standard is clearly met in this case. By the way, this is not the place to put that statement. This is the standard of review, not argument. Again, it's such a bad job. Whoever wrote this either rushed it or just didn't care. This is not the place for this statement. This statement right here goes at the conclusion, at the bottom, in 60 pages or so, not right here. Libel under Virginia law requires an actionable statement that is both false and defamatory, made with the requisite intent. Whereas here, a public figure brings the defamation case, the requisite intent is actual malice, a subjective inquiry which requires the plaintiff to prove that the defendant, in fact, entertained serious doubts as to the truth of her publication. Citing some cases, as the plaintiff and a public figure, it is Mr. Depp's burden to prove that the statements were false by preponderance of the evidence and to prove actual malice by clear and convincing evidence. That's New York Times, as we all know and love by now. Because the question whether the evidence in the record in a defamation case is sufficient to support a finding of actual malice is a question of law, Virginia appellate courts must conduct an independent examination of the entire record. The court does so by examining the facts pertinent to the jury award and exercising independent judgment to determine whether the record establishes actual malice with convincing clarity. That's the power of the court, and they're outlining it here. The court's duty to meaningfully assess the record is a constitutional responsibility that cannot be delegated to the trier of fact. So here they're saying the power of the court trumps and cannot be delegated to the jury. That's what Bose Corporation says. Remember what I talked about when I said that courts of appeals understand, they know what their duty is, but they're going to defer to the jury in making judgment calls based on the facts. So far, you have done a beautiful job arguing in the standard of review, which is, by the way, that is standard language. They probably copied and pasted that from a different case for the most part, because that stuff, every brief on similar issues is going to look exactly the same. Exactly the same. Like there's no magic tricks in the standard of review. The magic happens in the argument and the statement of facts. So far, we haven't gotten to the argument yet, but the statement of facts are very much lacking in substance of law. They're very emotional. So you've done a great job showing like you cannot let the trier of fact decide this. Now let's see how you tie it together. Tracy says, this case has a major effect on real victims of sexual abuse and domestic violence coming forward because Johnny proved it happens to both women and men, rich and poor, famous or not, but come forward and tell the truth. Yes, I'm working on that. I will have something behind me. This is not permanent. This is not permanent, I promise. Okay. background is not permanent. All right. Now we get to the meat. The argument. So they have 2 points, 2 major points. The first point is also further broken down into 2 parts, and the second point is broken down into 3 subparts. This is argument number 1. The jury verdict was plainly wrong to ignore uncontroverted evidence of widely recognized forms of abuse. And like I said before, and now I'm going to say it again, that is a terrible, terrible way to begin outlining an argument to the Court of Appeals. Why? Because being plainly wrong and ignoring evidence is not the job of the Court of Appeals. That is always deferred to the jury. And the Court of Appeals is going to defer to the jury because the jury sat in the room for 6 weeks. The Court of Appeals judges were not in the room for 6 weeks. So by saying they got it wrong simply means, well, maybe the defense didn't do a proper job. That's a they problem. Maybe the jury understood the case better than you're trying to outline here because of your self-interest in the case. That's a you problem. So Mr. Depp's defamation claims put front and center the question of whether Ms. Heard believed she was a victim of abuse. And yet, the trial court refused to provide the jury with an instruction on the full scope of what qualifies as abuse. Now, that's the argument. See, finally, we're getting, remember, I talked about this. This is the piece that's the most important. They're saying this jury instruction should have been included. That's the argument. This is so far the only piece of meat in this entire brief. See hearing transcript, The jury was left instead to reason by negative inference based on the instructions it received on the elements of falsity and actual malice. As a result, the jury's verdict completely ignored uncontroverted evidence that Ms. Heard endured numerous forms of well-recognized non-physical abuse, including emotional, psychological, and verbal abuse. The jury's verdict was therefore plainly wrong and must be set aside. Now let's get into it. Undisputed evidence demonstrates Ms. Heard was subjected to emotional, psychological, and verbal abuse. How are they going to be proving it? Let's find out. This court's independent examination will reveal that the record is replete with audio recordings, videos, text messages, and other indisputable evidence establishing the non-physical abuse suffered by Ms. Heard. Again, not the judge's jobs. For the most part, they're going to defer to the jury. They will look at it. No question. They will look at it. But they will defer to the judgment of the jury. Ms. Heard testified, and Mr. Depp admitted the numerous instances of vicious name-calling, manipulative attempts to control her career, accusations that she had been unfaithful, and threatening behavior. For example, Mr. Depp repeatedly degraded Ms. Heard verbally. While beyond the focus of this Amici brief, Ms. Heard was also physically and sexually abused by Mr. Depp, as supported by ample evidence in the record. Did somebody take, this is what I want to know, did somebody take like one of those Twitter threads and turn them into a brief? Be honest. Come on, this can't be real. Did the lawyers literally go on Twitter, find like one of those Twitter threads written by one of those Amber stands, and we're like, you know what would be a really good idea if we wrote a brief about it? This has to be a joke. This has to be a joke because, again, this is not what Amicus briefs purposes are. This is not what you do. Is this just more PR stunt? Which is fine. You know, go ahead, do your PR work. It's failing. Keep trying. I'm not trying to silence you. Please keep doing it. You're providing entertainment for us all. But Attempting to retry the case is not what appellate. How many times have I said this tonight, by the way? This is not what the appellate court's job is. This is not what the appellate judge's job is. I'm afraid I'm going to be saying this a whole lot more. He just admitted there was no physical abuse, so she lies, says Axel Oz. No physical, but a bunch of other, apparently, according to them. This is weird. I remember seeing all this stuff in a Twitter thread one day. The jury was there. They heard all this stuff. I'm not even going to entertain reading it. In an audio recording, Mr. Depp called her a fucking cunt. Because she probably was acting like one. I don't know. In another recording, you stupid fuck. And an audio recording, like, are you serious? They threw this into the brief? Gotta be beautifully damaged. There's gotta be Dr. Proudman's idea. I agree with you. This is wow. Okay, we're breaking precedents. Twitter has made its way into the court system. Shut up, fat ass. When Ms. Heard told him to put his cigarettes out on someone else instead of her. In text communications, Mr. Depp, you sicken me. Leave me fucking be. Like, again, I as an appeal judge would probably scroll through this. Like, it's not substantive. It's factual. In an audio recording of having a fucking lover or describing her feelings, screaming like a banshee, referencing exchange text and audio recordings, confirmed recent argument. The jury heard all of this. And they still made the determination. In a text message, admitted drugs and alcohol turned him into an angry aggro engine in a fucking blackout who sprayed rage to the one I love. He drank all night before I picked Amber up to fly to LA this past Sunday. Ugly mate, no food for days, powders, half a bottle of whiskey, 1,000 Red Bull vodkas, pills. Like, okay. By the way, where's the reference to the record? Oh, oopsie. I think, oh no, never mind. No, it's right here. It's right. I was like, oh, you made a typo. No, that would have been fun if they made mistakes. But they're referencing the trial record. Okay, so they're doing a job. But again, Mr. Depp wrote an apology to Ms. Heard stating, I don't want to be conditioned to continue that. Again, this is like, it's a Twitter thread. Text communications to a friend. Let Amber burn. Let's drown her before we burn her. I will fuck her burnt corpse afterwards to make sure she is dead. Hopefully, In text communications, Mr. Depp preferred to. Again, I am shocked that they actually included this. This is written like a sociology paper. I swear to God. Like, even, like I said, a college student would probably have done a better job writing a legal brief. This is insane. This is unprecedented. I've never seen this before in my life. Well, technically, it's maybe not necessarily, free speech. It might be considered hate speech, but it at the end of the day, it is free speech. Axel. To include it in a legal brief where the judge's job, this is a PR move. They're just, when you're on the losing side of an argument, this was a theme in this case. This has become a theme. When you are on the back foot, you have to attack. Right? This is Sun Tzu, the art of war. When it's better when you are in a defending position to attack first, because that will surprise your enemy. This is a PR move. This is a PR brief. This is not a legal brief so far. I don't know if it will change in a minute, but so far, no dice. This is not how you write an amicus brief to appellate judges, to try and persuade them that the side you're supporting is correct. Mr. Depp also I mean, I understand what they're doing. They're going like, all right, so he didn't physically beat her. We get that. But he did all this other stuff. And the argument is, and the only argument that they have so far, is the judge should have instructed the jury on that abuse. But the judge said no, and that's an error. And we support Amber Heard's brief, which we will read presumably on Friday, as to why. Including repeated, alarming, and violent attempts to exert control over her. Again, audio recording, photographs, documented videos and photos, text communications, confirmed in his testimony. Further still, Mr. Depp repeatedly acted in a threatening manner towards Ms. Heard, engaging in physically violent outbursts and destroying property. So she drove him to that position. Hey, Laura B in the house. How you doing? Everybody say hello to Laura. Hi, Laura. How could texts to his friends be psychologically abusive to her if she never knew about them? Excellent point. Excellent point. They're not addressing that. They're simply listing words. One thing I'm learning about legal briefs, says LB Mesemer, is they are not brief. Clever. I like it. Conista, I'm sorry, this is all available on the internet. I'm going to include a link in the description if I haven't already. I actually don't think I have, so I'm going to do it right now. But the bottom line is I'm scrolling past them because there's no substance. I'm trying to find the substance so that I can analyze it as a judge. I'm trying to show you all. I'm trying to read this as a judge would. And when I'm skipping over stuff, I am telling you, judges will be pretty much doing the exact same thing. I have seen judges read briefs. They do not take their time. Okay? They do not take their time. They want to get to the point. Give me the meat. Give me the point. Give me the information that I need so that I can make a decision. The more water you pour over this, the worse it looks. Did they watch the trial? Probably not, based on what I'm seeing so far. If they did and can put their signature on this, they shouldn't practice law. Well, I mean, look, it's just an amicus brief. So worst case scenario for them, the judges won't even look at it. Discussed previously. Further still, Mr. Depp repeatedly acted in a threatening manner towards Ms. Heard, engaging in physically violent okay, I read that. Property. His bodyguard testified, captured on video, admitted that during an argument with Ms. Heard in a trailer, he did this. Destroying property is a tactic many abusers use to threaten their victims by demonstrating their capacity to engage in violence. Fantastic. In some cases, not in this case. It was a reaction to her raising his ire, as we saw in the videos that we did have. The cabinet video, the TMZ cabinet video comes to mind, if you all remember. I was intentional of her riling him up after the death of his mother. I mean, that's the most disgusting thing I've ever seen, personally. To try to do that to another person. And he still maintained his cool. He broke shit. So what? He let his anger out on property. Not the best coping mechanism, but hey, it's the only thing he had at the time. Pixie Doll says, that makes me feel better. I'm not exactly sure what you're referring to, Pixie Doll, but I'm glad I'm making you feel better. These examples of Mr. Depp's undisputed conduct were not an exhibition of common couple violence experienced in some relationships. By contrast, Mr. Depp's behavior fits a paradigm of serious chronic abuse designed to dominate one's partner and to exert general control over the relationship, which is manifested in the use of a wide range of power and control tactics, many of which are non physical. By the way, all of these quotes and citations are not in case law. Remember, we saw like the 7 or 8 pages of stuff that they wrote in the beginning after the case law, the other authorities that they had. That's what they're citing. They're citing all these other authorities. These are not legal authorities. These are just people who have written articles on the topic. In fact, Mr. Depp's undisputed conduct is also consistent with numerous factors scholars have identified to assess the risk of grave. They're giving the judges a fucking class in sociology and domestic violence. Are you kidding me? They're not going to care. I'm telling you right now, they are not going to be influenced by this stuff. This is not what the appellate process is for. This is insanity. They've identified and assessed the risk of grave danger and death in abusive relationships. Right. Okay. Again, the reason I'm laughing is not, this is horrendous stuff. Don't get me wrong. I am laughing because the audience that this is directed at, the audience that they're directing this stuff at, are appellate judges. This is not NBC Studios. This is not Warner Brothers making another movie. This is a court trying to determine whether or not there were errors made in the court below. So far, you have spent literally 2 paragraphs. What page are we on? I want to know what page we're on. Give me 1 second. What page? We are almost halfway through, and so far, I have seen 2 paragraphs that are on point. 2. This is unprecedented. This is almost like that time Nancy Pelosi, after Donald Trump won the election, remember she had that rally where they're like, we're going to like take back the White House or whatever the fuck she was doing. That's what this reeks of. This is like, we are going to break all protocol. We're going to do something no one has ever done before. And please pray God that it works. Not a good look. Oh, hey, Hillary. What's going on? My LA buddy is in the house. Say hello to Hillary, everybody in the chat. Retired Nana. That video she says that video was after his business manager embezzled over $100 million. I would break things too. Is that right, Laura? This is nuts. This is literally breaking all precedent. All precedent. They forgot who their audience is. They forgot that they're not on Twitter anymore. Hey, Dorothy, not in Kansas anymore. This is the real world. Wow. Okay. All right. Identify to assess the risk of grave danger and death in abusive relationships, including has the physical violence increased in severity over the past year? Has the weapon or threat? Is he drunk every day or almost every day? Does he control most of all daily activities? Does he use drugs? They're trying to retry the case. They're literally trying to have a second bite at the apple. It's going to fail. It's going to fall apart. I'm telling you, the judges are not going to entertain this shit. It's a PR move. I am absolutely convinced this is a PR move. That's absolutely wild. I mean, here's the bottom line. they are going to use this as a tool to show, look, we have so many people that support her, and they're going to use this as a tool to get more PR on behalf of Amber. Is this going to influence the decision of the judges? Absolutely not. All right. Let's see if we can find some substance in here. The Again, undisputed fact. These words, they dilute your argument. Undisputed fact: Mr. Depp brandished a knife and implored Ms. Heard to cut him, or else he would do it himself. You mean the knife that she gave him as a gift? Because she was so scared of him? Evinces not only a propensity for physical violence, but also his attempts to manipulate her. Right, he manipulated her so much that she decided to give him a gift of a knife. Depp's pervasive drug and alcohol use turned him into a monster. Depp was also no stranger to jealousy, as he himself texted, becomes irrational when she does movies. Jealous, fucking crazy. Again, facts, facts, facts. Give me the law. Give me the law. This is argument. We're past the facts. Give me the law. Even putting aside whether Ms. Heard believed that she was abused, which is all that the law requires in this case. Cite, objection, hearsay. The uncontroverted evidence outlined above clearly, again, there's the peppering word, demonstrates Mr. Depp engaged in abusive conduct and Ms. Heard was in fact abused. That's it? That's point A. Okay. I don't see anything. I don't see any legal argument at all. At all. Oh my God. Let's see if we find anything of substance. Virginia law, as well as national and international authorities and scholars, recognize Mr. Depp's conduct as abuse. Okay. Virginia law recognizes, now we're back to the law, non-physical abuse like that suffered by Ms. Heard. For instance, Virginia courts have recognized that evidence of violence or apprehension of bodily harm are not indispensable ingredients in divorce suits charging cruelty, and that mental anguish, repeated and unrelenting neglect and humiliation can amount to cruelty, as that term is used in divorce law. Finally, we have a case. This case recounts also how mental anguish, repeated and unrelenting neglect and humiliation may be as bad as physical wounds and bruises, and recognizing how much cruelty is abuse. Similarly, angry words, coarse and abusive language, humiliating insults and annoyances. So now they're going back to all the facts that they stated earlier, right? Now they're tying it into the law, finally, in all the forms that malice can suggest, may as effectually endanger life or health as personal violence, and afford grounds of relief to an injured spouse. This is another case, Solly versus Solly, from Virginia. Virginia courts regularly take verbal and emotional abuse into consideration in family law decisions. This is not a family law case, by the way. This is a civil case, demonstrating their recognition of the harmful impacts of non-physical abuse. Okay. When a husband engaged in violent verbal outbursts, in the case of Browand versus Browand, and spoke language which reasonably could be interpreted as threatening, the cumulative effect of these incidents and other marital strife provided the wife ample justification or excuse to leave. Okay, so in divorce cases, family law cases, we have it. Baksani versus Baksani, wife testified that she suffered both verbal and emotional abuse from husband during the marriage. Based on this evidence, we cannot say that the trial court abused its discretion awarding wife spousal support. Now we have a spousal support case, so divorce, spousal support. These cases are in here, but where are the defamation cases? Where are the cases that are related to the situation that we have here, where one person lies about another person and a jury decides that they lied, and therefore they were not abused. I'm waiting for it. Virginia state and local authorities have provided similar advice and guidance to victims of abuse. The Virginia Department of Social Services defines domestic violence similar to the sources discussed above, focusing on a pattern of behaviors intended to exert power and control in an intimate relationship. Virginia Department of Social Services. Okay. These abusive behaviors may include, but are not limited to, physical assaults, verbal assaults, threats, intimidation, destruction of property, and violence towards other significant people. The Department of Social Services explicitly states that it is very important to recognize that domestic violence is not always physical. This is their whole point, right? And that verbal, emotional, and economic abuse can have long-lasting effects, even if a victim is never physically or sexually assaulted. Did they just admit that she lied? Holy fuck balls. What have you done, Amicus Brief? In trying so hard. Oh my God. You accidentally overtried. Listen to this again. The Department of Social Services explicitly states that it is very important to recognize that domestic violence is not always physical, and that verbal, emotional, and economic abuse can have long-lasting effects even if the victim is never physically or sexually assaulted. My heart just stopped. But that's not what the op-ed was about. It was about physical and sexual abuse. Exactly, Axel. I'd say this continuing abuse legal by proxy, says 4C process. Don't disagree. They have repeatedly lied about the testimony and the facts. She begged him back even after she filed her TRO. Retired Nana says your look is priceless, and this was Tracy. I'm sorry. My mind literally just went on a fucking rocket to the moon. I can't believe they wrote this. I can't believe they wrote this. So we're basically admitting she was never physically or sexually assaulted, but she was verbally, emotionally, and economically abused potentially. And here's why. So they've completely abandoned. So they're admitting that she lied. This is huge. Wow. Hey, happy Thanksgiving, everybody. This is my gift to you. This is their gift to the world. A drinking game based on this brief, says Julie, would have me shit-faced after the first paragraph. Wow. Okay, so this means that they're abandoning basically the whole she really wasn't physically or sexually assaulted. So the whole thing with the bottle and the rape, all of that's out the window. That basically never happened. We're instead going to put since that failed, since those lies failed, let's try the next set of lies, and that is abuse via verbal, emotional, or economic. No, this is not it. This is only the beginning. We haven't even gotten to the second argument, the second point yet. This is just the second point under the first argument. But the hoops that they're jumping through, exactly, Warlock. Literally, you took the words out of my mouth. We still have plenty of work to do. We are nowhere near finished. I took a huge pause because I I did not expect this. I did not expect basically an all but a flat out admission that there was no physical abuse, period. The end. Jesus. You are doing more damage than good. I wonder if this is a paragraph that Proudman was personally responsible for. That would have been a hoot. Virginia organizations dedicated to domestic abuse awareness, education, and policy objectives also endorse definitions of domestic abuse that are not limited to physical abuse. A few of these organizations include the Virginia Sexual and Domestic Violence Action Alliance, the Avalon Center, Women Resource Center of the New River Valley. See definition here, defining domestic abuse as a pattern of behavior not limited to physical assaults. Excuse me. So we failed on the physical front. Let's go to the emotional front. Oh my God. You don't get a second jury trial. Thank you, Claire Harris. She says, bless you. Everyone else caught on that she lied. Ages ago, you've read out a couple of messages saying it to LOL. You need to go back over this later. Maybe. I'm just trying to cover as much ground as I can, you guys. This is unbelievable. This is absolutely unbelievable. Emotional abuse can be just as damaging as physical. Okay. Adopting definition of domestic abuse as pattern of abusive behavior, both emotional and physical abuse, can be devastating for the individual. Okay. Wow. I'm sorry, this language is just. Holy Mother of God. What have they done? They have the PR is starting to backfire. You see what happens, by the way? See what happens when you try to jump through hoops. Let this be proof, by the way, to true victims everywhere, that when you are in the right, like Johnny Depp, you will win. The truth wins. If you truly have been assaulted, you will win. You just have to go forward and report these people. Okay? And if they try to use scare tactics, do not back down. Keep moving forward. Because see what happens when you try to support the lies, you literally bolster the argument of the true victim. You bolster the argument of the real victim on accident. They did this on complete accident. And it happens when, and remember, again, the truth will always set you free. The truth wins. Truth will always come out in the end. And it's exactly what they've done inadvertently. Tracy says, do you think the appellate judges either watched, kept an eye on, or read about this trial? Unlikely. Very, very unlikely, but you never know. 4C Process says they even contradicted themselves. See footnote 7. Okay, there's another one. Julio says, weird. I don't remember Amber Heard ending her testimony with psych. Clever. Retired Nana says she never claimed financial or emotional abuse. She was still in the penthouse. Exactly. Never fear truth. The truth will always set you free. Holy crap. um, sorry. Um, Virginia is not unique in recognizing that victims may be abused in both physical and non physical ways. Government agencies, international organizations, nonprofit organizations, and domestic violence help centers have all endorsed definitions of domestic abuse that include various forms of non physical abuse. For example, the DOJ defines domestic abuse, that's the Department of Justice, as pattern of abusive behavior in any relationship that is used. Again, they're just definitions, more definitions. Such patterns may include emotional, psychological, and physical. Fantastic. Undermines an individual's success. Like, none of this is saying anything. The DOJ defines psychological abuse as including causing fear by intimidation, threatening physical harm to self, partner, children, partners. They're trying to retry the case. That's their problem. That's their biggest problem. They're trying to retry the case. Don't forget to like this video, comment below, subscribe to the channel if you haven't already. This is a shit show, you guys. This is an absolute madhouse. And we still have another brief to go through. Whew. And we have Amber's brief. Oh my God. Oh my God. They're just burying themselves. They're absolutely burying everything. And this is complete accident. They're accidentally intertwining truth in their campaign for trying to get PR for this. This is unbelievable. Similarly, the DOJ recognizes other patterns, of course, of behavior. Okay. Centers for Disease Control defines domestic. Like, where? Give me the point. Give me the point. This is all very educational, very good stuff, but it doesn't do anything for purposes of this case. The CDC recognizes domestic abuse includes psychological aggression, defined as the use of verbal and nonverbal communication with the intent to harm a partner mentally or emotionally. The jurors were there. They observed all this stuff. They had a chance to make a determination, insert their own judgment call as to what they saw and heard. They don't need an expert to come in and tell them things like this. People are very, very intelligent when it comes to making their own determinations based on facts presented and evidence presented. My God. The United Nations also defines domestic abuse, domestic violence. Pattern of behavior. We got it. You outlined a pattern of behavior. All these define this is a pattern of behavior. Moreover, influencing can take many forms, includes intended to frighten, intimidate, terrorize. Again, this just feels like a really long Twitter thread. I'm sorry. I saw 3 nuggets of information across half this entire brief. To evaluate whether this has happened, we look at number 1, embarrass or make fun in front of your friends, put down accomplishments, make you feel like you're unable to make decisions, use intimidation, tell you that you're nothing, treat you roughly. I mean, the amount of work that went into this, I'm not going to lie, is astonishing. But the result is going to be absolutely fuck nothing. Because this is not what an amicus brief is supposed to be about. You're supposed to use law, not appeal to emotion. Quote me on that. You're supposed to use law, not appeal to emotion in a brief, especially an amicus brief, because you're injecting yourself into the case saying, I have something to say. You judges need to listen. Emotion has no place in briefs. Judges don't care. Judges care about the law because judges are going to be writing opinions that are going to influence future decisions. Thank you, Ghost Ghost. Says, love your hair. Thank you. Thank you, Depp fan. Do you think Amber Turd? I hate that term, by the way. I know I know that it became popular during the trial, but I just personally I don't like demeaning people based on their last names. As funny as it may be because of like her crapping the bed and everything, I get it, but I'm personally just not a huge fan of that term. I don't think I've ever used it just because I'm not a huge fan of it. Depp fan says, do you think Amber insisted that her attorneys retry the case in the brief? This is not her brief. This is literally an amicus collection of organizations that are injecting themselves into this. So, no, I don't think she has. Use intimidation or threats to gain compliance, tell you you're nothing without them. Isn't this like half this stuff is what Amber did too? Call you several times a night, show up to make sure you are where you said you would be. That's terrifying. That's the stalker behavior. Use drugs, alcohol, blame you, prevent you from doing things that you like, chase you around the house, for example, saying, let's talk. Remember when Johnny was like, even a referee, man, like time out. You have time out. Like, let me be by myself. And she just runs after him. No, we need to solve our problems now. This is unbelievable. And they're like defining her actions more so than they're defining what he has done. That's the scary part. So this Twitter thread is backfiring with the truth, unfortunately for them. I can't call this a brief. I can't call this an Amici brief. This is a Twitter thread about domestic violence. And a very, very important one. Again, make no mistake. This is very, very good, valuable information. They have done such extensive research. This is really well written for a college paper. If you want to show to your friends, not appellate judges, which is who this is directed to. That's the difference. You forget your audience. You forgot who your audience was. Unprecedented. The National Domestic Violence Hotline similarly defines domestic violence, relationship abuse, and intimate partner violence as behavioral patterns. Again, more definitions, okay? I'm waiting for the point. To identify abuse, the National Violence Hotline utilizes a visual diagram of tactics known as the Duluth model. Is this the Darvo? Isn't this where Darvo comes from? An example of the power and control wheel is seen below, as such wheels are widely recognized. Using emotional abuse, using isolation, minimizing, denying, and blaming, using children, using male privilege, using economic abuse, using coercion and threats. This is the physical and sexual violence, which Johnny, they just admitted, never did. So why are they facepalm? I am facepalming so hard right now, you guys. I can't even begin to describe how hard I'm facepalming right now. Because again, a lot of this stuff reminds me of what Amber was doing, using female privilege, using Johnny's children, minimizing, denying, and blaming, isolating Johnny from the world, ostracizing him from his friends, using emotional abuse, intimidating him, using coercion and threats. Now, economic abuse she didn't have because he had more money than her, but I'm sure if she could, she would. By design, the power and control wheel has 8 spokes. Bo Johan brings up a very, very interesting point. What if this whole brief was an assignment from one of Proudman's students, and this was the best one she could find. It's a very interesting theory. You know, I wouldn't put it past them. I designed the power and control wheel, has 8 spokes, each designed to categorize the pattern of actions that an individual uses to intentionally control, dominate their partner. 3 of these spokes, okay, I just read them. I'm not going to reread them. In recognition of this, states, including California, where Depp and Heard live together, they have added coercive control definition. Okay. Even the parties' respective experts, Curry and Hughes, for Depp and Heard, agree that domestic abuse includes acts of emotional and psychological abuse. So the jury heard about it. Fantastic. Legal argument, please. Still waiting. Dr. Hughes, preeminent forensic psychologist in the field, explained at trial that intimate partner violence is a pattern of manipulation, coercive control. It could be emotional abuse or psychological aggression. Dr. Hughes elaborated that it erodes autonomy, independence, yada, yada, psychological, okay. So there's the testimony, all right. Also testified regarding emotional abuse and defined it as denigrating a person's sense of self-worth and their self-perception through name-calling. Like when Amber said, "Be a man, Johnny, stop being such a baby," type deal. Or did I accidentally flip the script? Oops. Dr. Hughes' testimony also demonstrated that destruction of property is a risk factor for danger and fatality. Dr. Curry then also testified that intimate partner violence is abuse that can be psychological from, okay, again, great. She also agreed without qualification, domestic abuse is absolutely could be verbal and emotional, okay? In short, the legal argument, here we go. There is broad consensus that abuse is not limited to physical violence. Instead, the law and the... What law? Wait, what? What law? You didn't argue any law. You can't just say, and the law, by the way. What law? The joke continues. And the scholarly literature, which they have cited, absolutely. Now that I will give to them. They've cited it extensively, but it's meaningless. Recognize the impact of verbal, emotional, psychological abuse. Accordingly, the jury was plainly wrong. The jury got it wrong, and here's why. So they're basically arguing, Your Honors, we should have been in the jury room to present them with this stuff. Is this a joke? To disregard Mr. Depp's acts of non-physical violence in determining whether Ms. Heard's statement that she became a public figure representing domestic abuse was defamatory, and the trial court should have granted Ms. Heard's motion to set aside the verdict. So, okay, wait a minute. So it started off well. And then it just kind of went off the deep end. So it started off well. It started off, remember, let's go back. Virginia law recognizes non-physical abuse. They talk about divorce law, but I'm waiting for them to tie it back. You have to, when you write a brief, a quality brief, you outline the facts, you outline the law, and then you tie them together. What they've done here is they outlined the law, talked a little bit about the facts, talked extensively about the psychological research behind it, and then just left it. And they just completely left it. That's not how you write a brief. Okay. Allowing the verdict to stand. Now, this is their second argument. So the first argument has absolutely no merit because it's not based in law. It's based on emotion, and it's based on scholastic articles. And they're great. They're very informative, but they're not persuasive on appellate judges. This is like an emotional abuse towards the reader, says AP Seidful. Sorry if I'm mispronouncing that. To force a retrial it out of guilt. Yeah. Like basically, let's retry the case on paper. That's not how you do appeals. Any lawyer worth their salt would tell you this. Footnote 7, they say there was sexual violence. So they're even contradicting themselves. That looks even worse on them. That looks even worse on them. Allowing the verdict to stand. Let's go to argument number 2. Let's hope that we have some legal stuff here and not just appeals to emotion. Let's find out. Allowing the verdict to stand creates harmful chilling effects on abuse victims seeking relief. Due to the highly publicized nature of the trial, the ramifications of the verdict, if allowed to stand, will extend far beyond this case alone. Right out of the gate, let me just tell you, terrible argument to argue in any brief. The slippery slope of this case, look, you guys, we're sorry that Amber had to be the poster girl, but we need you to help undo the damage that Amber has done, please. So, appellate judges, we ask you to undo her fuck up by lying on the stand and using the Me Too movement and dragging the Me Too people through the mud and lying to the world. We need your help to kind of undo the damage that she's done. Is not a good start. Goddess of Mystery and Mayhem, thank you very much. Coupled with the intense retaliation Ms. Heard faced inside and outside the courtroom, the verdict will have widespread chilling effects on other survivors of domestic violence seeking to exit abusive relationships, get help, or speak out against abuse. Wrong. It is going to have a chilling effect on liars who are trying to lie about people abusing them, which is exactly what we want. And it is going to encourage people who have been abused, like Johnny Depp, to come forward. So that's already like just a misleading statement on its face. The chilling effects will be clear. Again, there's that word, clear. Just talk about them. Don't classify them. Detracts from your argument. We see this time and time again in this brief. First, victims may avoid seeking legal redress. You mean like Johnny did when he went forward and won? To the contrary, I think that will encourage victims, such as protective orders if they fear the orders will indirectly become the subject of retaliatory litigation against them, such as in a defamation suit or in family court proceedings. Cute argument, but falls on its face immediately. Second, abusers may feel emboldened to engage in retaliation through actual or threatened litigation against their victims. Actually, here I disagree again because of what Amber has gone through with public scrutiny, completely burying her existence because of her lies. To the contrary, I think victims are going to be very, very happy to come forward because of this case. This case has highlighted that if you are truly a victim, the public will help you and the truth will set you free. So again, it's all right, let's keep reading. Further subjecting victims to their abuser's control and crippling them both emotionally and financially. Third, the verdict amplifies an environment where victims are doubted. You mean where liars are doubted. Victims, true victims, will not be doubted through the legal process. And their credibility is questioned. Well, yeah, when you're lying, your credibility is always going to be questioned, discouraging them from pursuing legal relief and undermining their ability to obtain it. If you're a true victim, you're not going to have this problem. These issues are addressed in turn below. All right, let's get into it. just because I need to drink after. I don't drink alcohol, but thank you very much, Beautifully Damaged. I'm going to get a coffee with that, or maybe not a coffee at this hour, but something else, like an orange juice. The verdict discourages domestic abuse survivors from seeking protective orders. What? Oh, I can't wait to read this. So the Johnny Depp Amber Heard verdict is going to dissuade abuse survivors from seeking protective orders? Well, if they're lying, yes, absolutely. And that's what we want. We want to discourage liars from seeking protective orders. That's the truth. Protective orders are a critical tool in the fight against domestic violence because they are proven to deter physical violence, keep victims safe, and reduce the severity of future abuse. Absolutely. I agree. Studies have shown they also confer psychological benefit to victims. Well, sure. The challenge statements at issue in this case do not mention the May 2016 protective order Ms. Heard obtained against Mr. Depp more than 2 years before her op-ed was published, probably because it wasn't relevant to the case. But Mr. Depp's legal team was intent on framing the very act of Ms. Heard seeking the TRO at the heart of the injury for which Mr. Depp sought redress. During opening statements, Mr. Depp's attorney stated that after Ms. Heard filed the restraining order, Johnny Depp's name was forever associated with the image of an innocent, battered woman. Johnny Depp's name was forever associated with the image of an innocent, battered woman. Okay, they're talking about Amber when she lied about the TRO. Counsel for Mr. Depp further described how the act of Ms. Heard's obtaining a restraining order forever changed Mr. Depp's life and reputation through the resulting media storm. By the way, remember one of the things that you learned day one of law school? Opening statements are not evidence. You ever heard that? And the judge lets the jury know that opening statements are not evidence. Closing arguments are not evidence either. Whoever wrote this, I want to know if they actually spent at least 1 day in law school. That's what I want to know. Forget graduate. There's no question they didn't graduate. But did they spend at least 1 day in law school? So far, it's proving the answer is no. Andrea Burkhardt tweeted that she has both briefs. Awesome. Oh my God. Andrea is phenomenal. She's an appellate lawyer, and she is going to do the second portion of this, dissecting them. When she does that video, which usually takes her about a week or so, absolutely go check out her channel. Go subscribe to her. Go check her out. But yeah, they're available publicly. I tweeted about them, so they're out there. Okay, let's get back. So indeed, while Mr. Depp's trial team occasionally referenced the statements in the op-ed upon which his defamation claim were based, time and time again they made clear that the true origin of the lawsuit was Ms. Heard's filing for a restraining order. And this is a direct quote from the trial. We're not going to read it. We know where this is going. We understand where this is going. You talked about it, therefore you opened the door. That's the argument. You talked about the TRO, even though it was not supposed to come into the trial, but you talked about it. Now you opened the door. Mr. Depp's success at positioning a protective order as the root of his alleged financial and reputational downfall will chill victims from seeking protective orders against abusers. You mean the stuff that's not evidence? That we literally just said is not evidence. That the judge instructed the jury is not evidence. You're telling the judges that not evidence that was said in opening statements is somehow going to influence the course of conduct of abuse victims moving forward for the rest of eternity? Are you fucking kidding me? Is this your argument? Seriously? How did you even gather the courage to write something stupid like this? A slippery slope argument is seldom good, but this is just atrocious lawyer work. Forget everything else. Come on. I expected something of substance, like a grain of sand of something for me to be able to relate to my viewers, to tell them, look, this is their argument, this is going to be the counter argument. There is nothing here. We're like almost 2/3 of the way done with this. I'm still waiting for stuff to like come out of substance. Something interesting, something useful, something that the appellate judges can actually look at and read and go, all right, this is something that we should probably investigate or use in consideration of. This is absurd. This is absolutely absurd. Crystal 22, that's all she can afford for a lawyer. That's not hers. It's not even hers. It's people injecting themselves into this trial. What the fuck have you done? What have you done? You are destroying this case for her. We don't even need, Johnny doesn't even need to write a response anymore. You did it for him. This is unbelievable. Mr. Many abuse victims will likely come to question whether seeking legal redress or protection is worth the risk of having to face separate or protracted legal proceedings and potential liability, forcing them to relive their trauma at tremendous personal and financial cost. Domestic violence advocates have discussed extensively how Depp v. Heard may cause victims of abuse to shy away from seeking. There's a typo right here. Victims of abuse to shy away from seeking legal recourse due to the retaliation, harassment, and credibility attacks they face. This chilling effect will have devastating consequences for victims of abuse due to the well-established benefits protective orders provide to people facing domestic abuse. Again, you have said nothing. You have still said absolutely nothing. Like, you're not wrong. You're not wrong, but it's not a legal argument. And it doesn't help in any way, shape, or form in this case. It detracts from Amber's case completely because it's not a legal argument. It doesn't do anything. It's a research paper. It's a sociological research college paper, not a brief. This is not an amicus brief. While the terms of protective orders vary by jurisdiction, they generally enable victims of abuse to petition and obtain stay-away orders. Okay. Violations can result in civil penalties. Yep. Studies have shown that they are a key aid in the prevention of domestic violence. Fantastic. It's still, again, where's the argument? Crucially, one study says this. Fantastic. Give me substance. There's still no substance. This indicates that the very act of pursuing their legal rights, the National Institute of Justice, the research arm, is similarly recognized, but okay, more definitions. Beyond the actual reduction of violence, there are psychological benefit to protective orders. Victims view, yes, right. This in turn may help support victims' decision to leave. Excellent. Next. Indeed, the NIJ knows victims are violated by their, okay. In Virginia, protective orders offer many avenues. There we go again. More explanation as to what they are. The judges are not going to care about any of this. I'm telling you right now. This is nuts. It is crucial victims continue to access resources. The core purpose of protective orders to protect victims. Yes, it is. Finally, you cite a case, but again, you're just defining. Tie it in. I'm waiting for the tie-in. A judge on the juvenile and domestic relations district court may, for example, issue. Okay, so we're providing some examples now. They can do this. Virginia Code annotated allows this. Virginia courts recognize these protective orders ensure safety. Great. Next, chilling effects on the verdict stand to impact thousands of Virginians who have secured protective orders. No, it's not. Again, slippery slope arguments. They never work. Next, allowing the trial court verdict. Okay, so this is their conclusion. They skip the argument. They define. They're great at defining. They're showing their powers of research are impeccable. Look at how well we can research, judges. That's not an argument in an appellate brief. Written by Cat Tenbarge, says Julio. Who knows? Maybe she contributed to this as well. Allowing the trial court verdict to stand threatens to undermine this critical source of relief by deterring victims who fear retaliation. Again, but the legal argument, where's the legal argument of how it ties to this case? It's not here. We skipped over it. The consequences will be widespread. You are begging the definition. You've literally defined the conclusion in your introduction, and now you're defining the introduction into your conclusion. It's a closed loop with absolutely no substance. That's not how you argue an amicus brief. Some victims may choose to dissolve their protective orders. Future victims may choose not to pursue protective orders at all. So basically, they're saying this case is going to have such a profound effect that not evidence that was said in opening statements is going to influence people everywhere for the rest of existence. Not a legal argument, not a good argument. Slippery slope is a fallacy argument. Look it up, writers of this brief. Point number 2, the verdict emboldens. So this is the next point. So not only is it going to dissuade people from filing TROs, which is complete horse shit, now the verdict also emboldens retaliatory defamation lawsuits. So what Johnny did, now everyone's going to start doing, that's going to be their argument. Further chilling victims from seeking relief. If allowed to stand, the success of Johnny Depp's retaliation strategy will embolden abusers to engage in legal abuse, including through the filing of defamation suits in response to abuse allegations. Mr. Depp followed a playbook increasingly employed by powerful individuals to retaliate against those who accuse them of abuse. Okay, hold on, pause. What playbook? Who has done this before? No name comes to mind. So what is this playbook? Like the playbook that he created out of truth, that he weaved out of facts? That's not a playbook. That's called having a case, which he won, by the way. Mr. Depp followed a playbook increasingly, again, I would like to see who has employed it successfully, and the public and the jury was like, yeah, no, we still think you did it. When was there a defamation lawsuit filed? Nothing comes to mind. Nothing comes to mind. Because they're not citing any cases. They're not citing any articles. They literally notice that this statement in isolation means absolutely nothing and detracts from the argument. Once again, Mr. Depp followed a playbook increasingly employed by whom? Powerful individuals like whom? To retaliate against those who accuse them of abuse. Where are they? Notice how there's no number here. There's no citation to anything. Prominent artists, athletes, and business executives are among those who have filed defamation lawsuits in response to allegations of sexual misconduct. Now we have a cite, and that's fantastic. She said he sued. Me too, defamation, libel. So yes, it should be happening. And if it's happening, that means that there is a reason for it, and that means that there is a lot of false accusers coming out of the woodwork. And false accusers deserve to go to prison. Critically, however, the use of retaliatory defamation lawsuits extends well beyond the celebrity spotlight. It has become a strategy through which perpetrators lock survivors into years of abuse. Don't forget to like this video, comment below, subscribe to the channel, hit that notification bell if you haven't already. We still have, not today, I promise this is going to be way too much for everybody. Our nervous system can only take so much, but we're going to be covering the other amicus brief and Amber's brief when it's filed. Whew, this is going to be an exciting Thanksgiving week. My God, this is turning out to be way more eventful than I ever thought possible. By typing victims up in years of retaliatory legal abuse and defamation litigation, and thus attacking their credibility, perpetrators are able to continue the cycle of abuse even after victims have escaped or attempted to escape their abusive relationship. You mean like when Johnny tried to run away from Amber and she kept chasing him around? Okay. When a victim has left an abusive relationship, previous methods of abuse may no longer be as accessible to the abuser. Thus, abusers may turn to legal abuse to continue the cycle of violence. It is known that many abusers use litigation to harass and control ex-spouses and partners, and that perpetrator of domestic violence may use the legal system as a tool to maintain power and control over their former spouse or partner. Again, not saying it doesn't happen, not saying it's impossible, but it did not happen in this case. And using that as an argument to overturn the verdict in this case, because it may happen in the future in other cases, is the worst possible legal argument you can possibly conceive of. And it's actually not a legal argument at all. It is an argument, again, of slippery slope. It's a legal fallacy that judges are going to completely ignore. Indeed, abusive litigation in the domestic violence context has been recognized by state legislatures who acknowledge that the legal system unwittingly becomes another avenue that abusers exploit to cause, again, it just goes on and on. Now they're going into legislation. In addition to defamation lawsuits, legal abuse may occur in the context of dissolutions, legal separations, parenting plan actions, modifications. This is all true, but it didn't happen in this case, and the slippery slope effect has no effect on the decision of the judges in this case. Again, it seems there's a pattern here. Have you noticed a pattern? Writers have continuously neglected who their audience is. They keep forgetting who is going to be reading it. It's not college students. This is why I'm convinced that this is a pure weaponized PR piece of paper. It is purely going to be used for PR because there is no legal substance here. There is nothing that is going to work for purposes of persuading the judges in this case. In recent years, there has been a sharp rise in the number of defamation lawsuits filed against abuse victims. Since 2014, over 100 defamation suits have been brought against individuals raising sexual assault and harassment litigation, and cases have been filed at a faster rate since 2017. Again, you know what that tells me? That tells me that there are two groups in that category. One, the one that they're talking about, and two, there are more people not afraid to attack people who are accusing them of abuse when it never happened, which is phenomenal. This has been documented through studies and also firsthand observations of practitioners. Many of these suits are brought in response to allegations of workplace sexual harassment or sexual assault on college campuses where the victims voice their allegations online. Okay, again, not the case here. The threat of a defamation suit is particularly effective at deterring victims from seeking relief, given the power imbalances that are often inherent in abusive relationships. You mean that Amber thought that she was a woman and she's going to be believed by default, and that Johnny Depp, go and tell them, Johnny, the world is not going to believe you, a man, was abused by me, a woman. Is that what you're talking about? That power imbalance? The female versus male dichotomy? Is that what you're referring to? The threat of due to the financial burdens imposed on defendants through these lawsuits, poor Amber, she had to hire a bunch of defense lawyers and appeals lawyers to fight the shitstorm that she caused. Survivors may not be able to effectively mount a defense against such claims. So far, she's done a pretty good job. Survivors face the risk of being bankrupted by defending themselves. Okay, just because they risk bankruptcy for their lives does not excuse their behavior. By defending themselves in a defamation lawsuit. The risk is exacerbated by the fact that many abusers engage in economic abuse by restricting their victims' educational and employment opportunities to prevent them from gaining financial independence. Which I'm sure it does happen, but it's not the case here. And slippery slope doesn't work, as we talked about. This means many victims have far fewer financial resources than their abusers to begin with. Thank you, Salem's mom. She says, love your channel. Thank you for all you do to keep us informed. You're welcome. You are welcome. This means many victims have far fewer. The mere threat of a defamation suit, even if not actually filed. Oh, now here they're calling out their own bullshit. They literally just called out their own bullshit. Listen to this. The mere threat of a defamation suit, even if not actually filed, may therefore present an effective and coercive legal strategy to control and silence abuse victims. Literally what they just said, but everything we wrote above doesn't mean anything, because just the threat creates the threat of people retaliating. So it doesn't even matter if they file. They can just threaten. They literally undid all the work. All these paragraphs they've just written, they undid with one sentence. The mere threat, even if not filed, can pose a threat. Oops. I'm telling you, this was not properly reviewed. This was not properly written. These lawsuits also have harmful emotional impacts on survivors. Victims are re-victimized through legal proceedings. So what? So take away their ability entirely? Oh, come on. Are you trying to, like, again, this is the whole Twitter, I don't like what you said. Hey, Elon, can you please block them for me? How are they even allowed to still speak? They should not be permitted to speak. Why are they still speaking? Wah, wah. Stop speaking. Wah. It hurts my feelings. Wah. Take away their right to file civil suits. Wah. Don't give them opportunities that are permitted by the legal process in the United States of America. Wah. Come on. Come on. Is this really your argument? Is this a joke? Victims are re-victimized, As in Depp v. Heard, the litigation becomes the mechanism through which a survivor must document and participate in his own spectacular humiliation in front of a judge and jury. You mean when she sat there and smirked on camera, having a whole lot of fun, greeting everybody in the morning? When she was so happy and excited, hoping that she would win? And you mean the humiliation that she had to endure because of her lies? She absolutely deserved all of that. She must not have told him about the blackmail letter, says retired Nana. So absolutely, liars deserve to be exposed. Are the Amicus Brief people, these women's organizations, are they actually trying to argue that, look, we have liars in the field, you guys. We need to stop outing them. So even if the woman lied about the allegations, it's okay. There's just enough. This is always their argument. Like 9 out of 10, 99 out of 100, whatever numbers they make up, are true allegations. So the 1 or the 2 over there that are liars, we need to kind of sweep those under the rug. That's their argument. That's basically what they're saying. We need to sweep under the rug those few that are actually lying about getting abused. Let's not worry about those. Let's focus on the big picture. Let's focus on the big picture. If we scoop up a few liars in there and these men go to prison and their reputations are ruined and the women lied, so be it. It's okay. It's the sacrifice that society has to make in exchange for all these other women. Are you fucking kidding me? Are you fucking kidding me? You've heard the phrase, it is better to let 9 guilty people go free than to convict an innocent man. This applies here to the T, to the absolute fucking T. You don't have a right to defame someone and to lie about them and then seek protection from it. It's not how the world works. Additionally, the strategy in these defamation lawsuits is to recast the actual perpetrators of abuse as victims, thereby increasing the sense of hopelessness, fear, and trauma victims may experience if they feel like the legal system not only cannot protect them, but can be manipulated. I mean, they're stating facts. Again, they're stating things that are real in society, but they have in no way relation to this case. That the threat of being sued deters many victims from speaking out about abuse is supported by scholarship as well as experiential evidence. Survivors now have to determine the likelihood abusers will bring defamation suits or other legal retaliation before deciding whether or not to seek help or speak out against abuse. I mean, it's a fact of life, unfortunately. There's nothing that the judges can do with respect to this case. They're not going to decide against Johnny Depp just because it hurts some other cases somewhere. They have to decide the case on the law in this case, on the merits of this case. Ridiculous. The threat of defamation suit may lead victims to question whether they can speak out of abuse at all, even in order to seek the protection they need. See Doe versus, all right, finally we have a case stating that victims informing family they have been sexually assaulted should be privileged as a matter of public policy, because otherwise victim would have to weigh, on the one hand, the value of reaching out for help in the aftermath of a traumatic sexual assault, and on the other hand, the risk that they could be subject to civil liability for defamation in the occurrence of sexual assault is contested by the alleged perpetrator. It's a Maryland case. It's not even Virginia. So the judges can look at it and go, okay, next. The verdict below amplifies this dilemma for abuse victims while reinforcing abusers' efforts to weaponize defamation law. Again, doesn't apply to this case. It maybe applies to other cases, but we're talking about this case. So as a powerful means of quashing both past and future allegations of abuse. This, again, anybody who wants a research paper, a very informative research paper about what true abuse looks like, this is it. This is a phenomenal piece of writing. Again, I'm going to give credit where credit is due. It is a phenomenal piece of writing, but it has absolutely no place in front of the Court of Appeals judges in the Court of Appeals of Virginia. That's where it does not belong. It has absolutely zero merit with respect to the case itself. It is a phenomenal piece of literature with respect to victims' rights, and what could potentially, in theory, happen in these types of cases. So again, I'm giving credit where credit is due. It is a phenomenal piece of writing as a research paper, not as an amicus brief. The verdict fosters a climate. This is the third point under the second argument. The verdict fosters a climate of second-guessing victims. Don't we want that? Amber has proven that we want to second-guess what victims are saying sometimes, especially when there's no evidence to support anything of the sort. Think about it. This is literally what this case has been about, second-guessing what Amber has said. After 6 years of Johnny living in darkness, 6 years he had to endure sitting there, listening to what the world had to say about him before he finally got a chance to speak his piece. And then we decided to second-guess Amber. Look what we found out. So you're saying we need to stop and make sure that future liars are not ousted and outed to the public? Is that what you're asking? That once they're labeled as a wife beater by a court somewhere, some judge somewhere with no jury process, just leave it at that? Call it a day? Is that seriously what you're about to argue? Oh boy. Let's see. The verdict of Mr. Depp in the face of, again, uncontroverted evidence. Drop those words. Uncontroverted is a terrible adjective. in the face of evidence of abuse. That's it. Uncontroverted detracts from your argument. Now I don't believe it's uncontroverted anymore, since you had to bring it up, since you had to say it. The verdict for Mr. Depp in the face of uncontroverted evidence of abuse also furthers unrealistic standards in the eye of public opinion as to what qualifies as credible victim testimony. This is the Amber is a terrible poster child for victims everywhere argument. And please undo the fuck up that she's done once again. Oh, Lord. Ms. Heard's credibility was continually undermined. Yeah, duh. Online through a firestorm of negative commentary on social media sites, including TikTok and Twitter, based on the things that we saw in the trial. Indeed, the Amici are now subjected to this firestorm because you're defending someone who we believe lied. I mean, if you're gonna be defending her, then you're going to be under attack too. There's nothing wrong with that. Welcome to life. Welcome to reality. You can't just shut up and block everybody who you don't agree with and go la 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 la. They don't exist. They don't exist. They don't exist. They don't. They're not here. They're not saying anything. La 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 la. I don't see it. Nope. If I don't open my eyes, it's not written there. If I don't open my eyes, it's not. Oh shit. If I just close my eyes and close my ears, it doesn't exist. You fucking children. You are children. Literally throwing a tantrum in a brief? You're throwing a tantrum in an amicus brief? Now, let me put it to you this way. Who's really abusing the legal process here, huh? I'll give you one guess. The attacks on Ms. Heard's credibility frequently employed common victim-blaming tropes that demonstrate a fundamental misunderstanding of abuse. Now, that's a fair statement, actually. The attacks on Ms. Heard's credibility frequently employed common victim-blaming tropes and demonstrate a fundamental misunderstanding of abuse. Sure, a lot of people are not fully educated on the subject, and they just heard something and they go, look, I believe she's a liar, and maybe they misstated why they meant that. That's not a reason to overturn a jury verdict. But, I mean, sure, it's a fair statement. Not everybody is on the same educational playing field on planet Earth. Hello? Anyone? Anyone home? The lights are on, but no one's home. These included criticizing Ms. Heard for not leaving Depp after the first instance of alleged abuse. Are they citing tweets now? And doubting Ms. Heard's credibility on the witness stand for displaying too much emotion. Oh, dear God. Johnny Depp, Amber Heard defamation trial TikTok documentary. Oh my God. Oh. All right, we got to get through this. Some of the most viral videos on TikTok pointed to every lip quiver and sigh. Who cares? The judges don't. This is not. I'm done. I'm not saying it anymore. I can't. I've said it too much. I can't. It is well recognized that victims stay with their abusers for numerous reasons, including the abuser's effort to exert control and create dependence between abuser and the victim. Staying with an abuser does not indicate a person is being untruthful about abuse that has occurred. Similarly, domestic violence victims can respond to overwhelming trauma by becoming emotionally numb. Again, all these are true things. Doesn't relate to the case, which may impact whether they are viewed as credible if they don't demonstrate outwards signs of trauma. So you're saying, guys, turn off your bullshit detectors, leave common sense at the door. If she says she was abused, she was abused. Period. The end. Next case. No. Society says no. That is not the way to go. Other victims may suffer from hyperarousal, that is, an anxious posture of alertness and reactivity to an imminent danger, which may cause victims to be subject to unexpected outbursts and lead to victims being perceived as out of control, even a bit crazy. So now they're trying to excuse her behavior through psychology. Oh, please. Oh, come on. The highly publicized failure in this case to understand how survivors may respond to abuse perpetuates harmful misconceptions about victim credibility that have long since been debunked by domestic violence experts. This is literally them trying to backdoor the argument of, yeah, we know she didn't look believable, but trust me, she was believable. Just like the hallmarks are there. The hallmarks are there. She was believable. Everybody thinks she wasn't. That's their problem. That's because they don't understand psychology. They don't understand victim behavior, which is complete bullshit, by the way. We have had in this chat right here, we have had people when I was streaming over the last few months who have said, I personally am a victim and I empathize with Johnny, not her. She displays all cues of being the abuser. This is what you all have said. You guys have said this. You ladies have said this. These people do not speak for you. They're starting to become afraid about how many women have lied about being domestically abused, Alicia. Holy shit, you just hit the nail right on the head. Mirror Man is one of them that was here. Yes, Sunny. People are saying they think that Amber is the one who wrote this. It's possible, but unlikely. The verdict, if upheld, will further contribute to an environment in which victims' actual experiences of and reactions to abuse, even when supported by uncontroverted evidence, credible testimony, which is not the case here, again, may be discounted or second guessed, both in and out of the courtroom. And that's going to happen in any publicized trial, so you're not going to stop that. That's a terrible argument. Such credibility discounting may discourage women from continuing to pursue justice or other forms of support. And again, if you are truly a victim, absolutely you need to come forward. And this is not going to discourage you. Look at Johnny. Johnny was a true victim. He came forward and he won. And you have a chance too. So absolutely. Power to the victims, the abused. Absolutely. No question about it. No power to the abusers. It is already well known that victims may shy away from seeking legal and police assistance when they experience domestic violence out of fear of being disbelieved, and this verdict threatens to exacerbate that barrier. Again, no legal argument at all. None. Zero. This has been an argument of emotion. Missy Jade says, I'm a survivor, and Amber Heard is an evil human being and should be in prison. Amber Heard has made a mockery of true survivors, and this is insulting. I couldn't agree more. For all the foregoing reasons, the Amici respectfully request that this court set aside the trial court verdict and deny Mr. Depp's claims for relief in their entirety and with prejudice. This appeal to emotion is completely and utterly pointless. And this is the list. This is the list of people who have signed up for this, and I'm going to call them out one by one. They signed off on this. These are the people that you need to watch out for moving forward in the future. These are the organizations and the individuals who have said, I agree with what is said in this brief, and I support and want to have my name added. There are 59 names here, so we're going to go, and we're going to go quickly. The Sanctuary for Families, the Virginia National Organization for Women, now, the DC Coalition Against Domestic Violence, Equality Now, Esperanza United, the Feminist Majority Foundation, the Battered Women's Justice Project, the Women's Equal Justice Project, National Crime Victim Law Institute. I wonder if these people even read the brief, or did they just like, yeah, sure, add my name to the mix. Terrible decision. Terrible decision if you did that. The Coalition Against Trafficking in Women, C.A. Goldberg, PLLC, a victims' rights law firm. Fearless, Hudson Valley Incorporated, Hope's Door, Media Watch, Movement of Mothers, the New York State Coalition Against Domestic Violence, One Mom's Battle, the Pixel Project, Possibility Seeds, We Spoke, Catherine A. McKinnon, Michelle Dauber, hey! Shelly, how did I know I was going to find your name in here? As a female domestic violence survivor, says Gamer Soldier, Amber Heard is not a victim and has no rights as a victim. Men get abused as well. Liars deserve to get backlash from true survivors and get sued for defamation. Men get abused too. I am sickened. Thank you for sharing, Gamer Soldier. I'm so sorry that you went through that. So Michelle Dauber, of course. Deborah Epstein, Lisa Sales, Renee Adams, Lindsay Boylan, Elizabeth Blackney, Dr. Stephanie N. Brandt, MD, Cheryl Bratt, Nancy Chai Cantalupo, Lauren Cataneo, Professor Gillian Chadwick, Dr. Andrew Thomas Cicchetti, Julia Devantheri, Margaret Drew, Kate Hugill, Dr. Holly Jacobs, Dr. Emma Katz, Aisha Ali Khan, Dr. Syra Khan, Professor Lori Cohn. I think these are alphabetical. Dr. Ingborg Kraus, Tammy Quenin, Julia Lee, Julia Livingston, Esquire, Lisa McDonald, Dr. Belinda McIntosh, Natalie Nanasi, Judith Olin, Tashmia Owen, Alexa Polar. Oh, there she is. I was waiting for her. Dr. Charlotte Proudman. Hi, Charlotte. Dr. Lily K. Ross, Rita Smith, Rosalind Toulousan, Camille Waring, Merle Weiner, Sarah Yokub, and Amy Ziering. Certificate of service, of course, that it was filed earlier today, November 23rd. It's available on the internet. The link is in the description below. It has been filed upon the Ben Chu, Rottenborn, J. Ward Brown, just to make sure that every single party receives a copy. That's standard procedure. Camille Vasquez, there's Axelrod. I hereby certify this is the certification of how many words are in this brief, that they did not go over the word limit. There you have it, folks. There you have it. This is the most unbelievable amicus brief I have ever read in my entire life. Now, granted, I haven't read many of them, full disclosure. But the purpose, remember 2 hours and 45 minutes ago when we started this video, I told you what the definition of an amicus brief is. Let's revisit that real quick. What is the definition of an amicus brief. Literally translated from Latin as a friend of the court. Generally, it is referring to a person or group that's not a party to the action, but has a strong interest in the matter. The person or group will petition the court for permission to submit a brief in the action intending to influence the court's decision. This is what they're trying to do. Sorry, I'm trying to like make it as big as I can. It's got a lot of things in the middle. This was the whole intent. This is what an amicus brief is supposed to do. It is not a let's plea to emotion time. Amicus briefs are reserved for parties to inject themselves into a case and to state for legal reasons, first of all, why they're injecting themselves, and second, why the court should rule in one party's favor over the others. They have absolutely failed spectacularly, Elizabeth Young. I couldn't agree more. I couldn't find a single piece of legal evidence as to why the jury got it wrong. They started off very poorly. Then they got on the right track. They started talking about how the instruction, the jury instruction was wrong. It should, we agree with number 14. Remember? The assignment of error number 14, that's what we're signing off on. The jury instruction was given improperly. It was removed improperly. It should have been included. Fantastic. That's your argument. Stick to it. They never again mentioned in 72 pages of writing, they never again mentioned what this is all about. They were like, this is what it's about, and then they went off into the deep end. This was absolutely an unprecedentedly a PR move. This is not a legal brief. This is a sociological essay about what could potentially happen in the future, not related to this case. If you read this amicus brief, imagine it not being related to this case, right? It still has some holes in it. It's got some poor arguments, but for the most part, it is an excellent collection of research about what a lot of victims need to know. No question about it. It is an excellent collection of essays that may help victims, but it is not a persuasive legal brief in support of why the jury verdict should be overturned. Just because you said, oh, and the verdict should be overturned does not mean that you have supporting legal arguments to show so. And we have just proven that by going over it. So, and best case scenario, it's very possible that the judges may look at it and see that Amber Heard has agreed to having this, to stipulated to this brief being submitted, while Johnny has not. And as a result of that, they may simply go, we're not even going to read it. We're not even going to entertain it. So, yeah. I hope you all enjoyed this rendition of the first brief. I'm going to try and get the second brief done tomorrow because I can't wait. The second one is First Amendment. The second one, actually, I imagine is going to be substantive, I hope. And then Friday, we're going to read Amber's brief, God willing. So Thank you all for joining me. Once again, don't forget to like this video, comment below, subscribe to the channel. I love every single one of you. I hope you learned something. I hope I eased your nerves, and I will see you all tomorrow. Don't forget, daily shows every day. I'm going live, God willing, every day. Bye, everybody.